Is they here? I think we're dealing with
Mr. Park.
Mr. Park from Mocha office. And the Mocha get involved in physical activity, like damage yourself now.
Just an unfortunate incident, sir. In the correspondence we received, we were only alerted to the point 14 on page 13 of the matrix. If the chairman could assist me with the other points that we're being asked to comment on, so I could deal with them collectively.
Section 10.6.14.
Distance from the school.
As related to distance from the school, activity taking place within the precincts of the school essentially, and applying that elsewhere. I think all the reference related to activities taking place within what we consider the precinct of the school.
Mm-hmm.
Right.
Very well, sir. So if you may recall, in our presentation, what was very important to us was the fact that young persons represent for gangs means of recruitment and furthering the life and existence of the gang. So it occurred to us that given that there is an aggravating factor in the second schedule that's attached to Section 4 of the Principal Act, which added an additional penalty if the recruitment of a child took place within 300 meters of a school for obvious reasons, we thought that it would be prudent to extend this aggravating factor to some other offenses or sections of the Act. Those sections are Section 5, which speaks to the recruitment of an adult to the criminal organization, Section 10.6, which criminalizes inciting or inducing a person to commit a serious offense or act of violence to promote or facilitate activities of the criminal organization, as well as inciting or inducing a person to commit a serious offense or an act of violence to hinder or prevent the investigation or prosecution of a criminal organization. Section 11, which criminalizes professing to be a part of or participant in a criminal organization, and Section 12, which criminalizes preventing a person from ceasing to be a part of or ceasing to provide a benefit to a criminal organization. This committee is well aware that, especially with regard to many of our non-traditional high schools, they are usually proximate or very close to garrison communities. And in some of these garrison communities, a lot of our gangs exist. And for obvious reasons, or rather, it is not hard to imagine that members of the gang and perhaps activities of the gang would be within the sight and or knowledge of the children attending these schools. Now, it is very clear that this aggravating factor was intended as a deterrent, and we viewed it prudent that you increase the deterrence to the recruitment of children or young persons to the gang. So it, in my mind at the very least, it's very easy for me to mentally play out how, for example, the disciplining of a gang member within the proximity of a school in the sight of children, the impact it may have. These young recruits are usually very impressionable. They may or may not have proper role models in their life, and they may look up to gang members or gang leaders due to the allure of the power and the trappings of their position. And it is our view that if we added this aggravating factor to the offenses identified, then it would be an additional layer or deterrent as far as law enforcement is concerned in sending the message that at the very least these activities are not to be conducted in the proximity of our schools, sir.
Thank you. Before I ask my colleagues to comment, I am a bit remiss. I should welcome the students from the Kingsway Prep School and two of their teachers who are in the gallery. Good to have you here. You can only, and maybe it's coincidental that we'll go there discussing negative activity that should not take place around, well, it should not take place at all, but in particular around schools, there'll be particular penalties for them. So it's an interesting point around here. I think we had agreed to the section 5, right? Yes. That means others that there were some questions being raised about being included in first 5.1 be regarded as an aggravating factor. It's the other section in 10 and 11, I think, that we had some questions. So, colleagues, legal man, in the comments, questions here. We accepting Mocha's recommendation now.
So just for clarification, you're proposing that the aggravating factor comprising the offense, if it occurs within a certain proximity of a school, that would be an aggravating factor in all of the same aggravating factor you're proposing, but for other offenses which you've named. Is that right?
Yes, sir.
Yeah. And just
I get the impression you're basically treating gang activity around the school as an aggravating factor. So even if they, am I right?
As far as these offenses that are identified are concerned.
He has, so the ones that you're specifically looking at, you said 5, which is recruiting an adult.
Could be brought in, conducting their activity, even though it's an adult around the school area. But we had raised questions on.
So just, Mr. Park, generally speaking, you're trying to create a sort of safe zone around schools. So even if the gang activity is not particularly targeted at the child, such as recruiting the child, but if it's even targeted at another adult, but within a school zone, and let's just call it the school zone, the perimeter, the area within, 300 meters. So any of that sort of gang activity that takes place within that school zone, you're saying should be subject to that being considered an aggravating factor on this for sentencing purposes.
Yes, sir.
Okay.
A part of the thinking behind it is that the watchful eyes of teachers and other responsible adults will not always be present. And this has a part to play in the sort of psychological war that runs parallel to what law enforcement does.
I think I'm beginning to understand now. We weren't so sure last time because we could understand where the target or the victim was a child, that would be, it being within a school zone would be an aggravating factor. But what you're really attempting to do is create a cordon sanitaire as you know, around schools, and so that any gang would know that this is really a no-go zone, and if they do go there, they're going to be subject to very severe penalties upon conviction. That's the psychological message that Mocha wants to send to organized crime.
Yes, sir, and it would be, in our mind, a positive side effect, because we are we're in a situation where we are encouraging whistleblowing. We are attempting to change perceptions of corruption and try to instill a particular value system. And we believe that this inclusion will assist in that exercise. As well as you pointed out, member, creating a sort of safe cordon or safe zone around the schools.
You have some schools in some areas, densely populated areas, that schools are really in communities. I can think of a few. So that in practice, if there's gang activity in those communities, it is likely to be within 300 meters of that school, taking place from time to time. If you have a densely populated area with a primary school, for example, located in it. So in a sense, the impact of these amendments on that community or the activities in that community would be essentially to raise the stakes significantly on having any gang in that community because the school is there. Yeah.
The conduct of the gang itself, because there are gangs who will conduct themselves different than their own children, and there are those who are just totally wild. I think it will send a good message to the entire community that it's not about of condoning, but we take special interest in seeking to prevent gang activity around the institutions. Given what's happening out there in terms of attitude to our children, it will be a very good signal coming out of this. Thank you, Nigel.
You're welcome, sir.
I think we're at any comments, Mr. Bailey? Ms. Grant, you're fine. All right. Okay. I think we can, in going back to the matrix, we are at section 15, offenses and penalties.
The reference in the matrix to point 14 in the MOCA column on page 13, there's a reference to point 14. Is that section 14?
No, I think that was Mocha's numbering of their submission.
So which section is the one of using real property?
We're looking at
Section 15.
section 15, 15.1. Mocha has a comment where they move change the use of property is the premises. That's point 14.
I don't think so.
No?
I don't think so,
What
no.
page is that? You have a page. Oh, page 13.
Let me check. Maybe. It's not it's not mentioned in the schedule.
When
Section
page-
15 is a general introduction of the schedule.
Right.
And the schedule has a list of all of the offense creating sections and penalties applicable to each. So I'm just asking which one deals with the issue of using property. I could hunt through the act and find it, but was wondering if anybody knew that offhand. And I noticed it said point 14, so maybe if you look at the MOCA document, which I do.
If I can attempt to assist.
Yeah.
In our recommendations, it's listed at point 11, which is on page 8 of our document. But if I recall correctly, I believe my friend Mr. Bailey had elaborated that the definition of property as it existed in the Act would have been sufficiently comprehensive to make our recommendation in this regard more or less moot.
Is property defined? Well, first of all, does anyone, where is the offense? Which section is the offense?
If I may, Member
Yeah.
Golden, in the Principal Act,
Yeah.
benefit is defined to include any money or other property, service, or advantage.
Right.
So when Mr. Bailey pointed out that very expansive definition, it sort of made our suggestion of the expansion of the use of the word property to include premises and other things more or less moot, because if you, for example, what we had been suggesting is that in the law reform legislation there was an offense which criminalized an occupier or owner of a premises that allowed that premises to be used for
Yeah.
scamming activities.
I'm familiar with that.
So our recommendation is that a similar provision be imported into the anti-gang legislation. But Mr. Bailey pointed out that the definition of benefit was sufficiently wide that if you provide a benefit to the gang, it would include making a premises available for the purposes of gang activity.
Yeah, but it's a somewhat elliptical way of getting to that conclusion. It might be worthwhile considering having an actual offense of using any premises in furtherance of gang activity, similar to the latter scamming
Yes.
legislation.
Yes.
Yeah. It's just in the matrix. It was
Is
a
This was, we're dealing in here.
So is the next point on page 15 of the matrix? And this is our law school recommendation in relation to the mode of trial. The trial for offences under this act is by judge alone. And they are proposing a panel of 3 or more judges, or a judge and a number of attorneys. I just think with challenges we have with backlog and the volume of cases in the court, I don't think we can judges to a case unless it's an appeal or a full court matter, as is now the case. But I think for trial of criminal matters, I don't think.
I agree. We don't have the resources, and this will only, choke up the system and slow down the trial process.
And there's no data to suggest that the trial by judge alone has flaw in it in terms of the outcome. The gun court, which is our best experience of serious crimes being tried by a judge alone, has some issues in terms of backlog, but that I think is to do with the administration of the cases rather than the court. Yeah, the issue with the gun court, I think, is it has a heavy caseload, and the manner in which the police have managed the caseload has been less than satisfactory at times.
Separate and apart from that, I think there is a misunderstanding as to who may adjudicate in a matter. In the Judicature Parish Court Act, in the land jurisdiction, there is provision for a parish judge to sit with lay magistrates, but they are jurisdiction, but you don't generally have attorneys sitting with the judges for the adjudication of matters, separate and apart from whether there would be sufficient number of judges available for a panel to sit on a matter like this.
I'm with you, understand in terms of on both points. The only question I asked there, of course, bear in mind, which might have, from a different point of view, usually you deal with large numbers in gangs of up to 20 people simultaneously. If there's more than one city going to make any difference. When they deal with because they're all tried in the same as a group. There could be some merit to looking at having more than one member on the panel. When you're trying a group like is that about, and currently there's a group that is trying about 20, 25. I'm not supporting the change. I'm just wanting to be explored that when you're going forward, trying 20.
Whether you're trying 1, 2, 5, or 20,
Yeah.
if you're having more than one judge hearing the matter, they would all have to be present at all times throughout the
Oh,
case.
all right. That's the one.
Yeah. Yeah, they'd all have to hear all the evidence, you know.
If they could be tried in the sense that if trying 20 persons one time, the judge gets ill, then they.
The system does not contemplate
No.
alternative judges because you have to be present at all stages.
Right. That's if they have to be there all the time, it doesn't make any sense. And you're just seeking more. You need more judges. All right. On 16, page 16 now.
No, you're not dealing with 17.2.
Yeah.
17.2, Mr. Chairman, where it speaks to the ministry suggests an amendment to include provisions for the protection of surveillance officers during operations investigations. I think this is something that needs to be addressed, but I don't think it's unique to this piece of legislation. And so I think it would more properly be addressed generally in either in the JCF Act or if we want
Criminal Justice
to.
Administration Act or
Right,
somewhere,
Criminal
some
Justice
general,
Administration,
yeah.
some thing. This is not limited to the anti-gang legislation. The issue of surveillance officers and truthfully, I think we need some legislation to cover the whole intelligence gathering field and would set out, prescribe the limits, the permissions, the protections as to identity, etc. But it would go way beyond an amendment to this section of the Criminal Justice Suppression of Criminal Organizations.
Chairman, I share the view that we should look at perhaps a menu of powers and tools available to the security forces that can be used across a wide subject matter, investigative tools, whether starting with intelligence gathering, ultimately cut into evidence for prosecution, because it appears that investigators are unsure what powers they have. The different things are scattered across various pieces of legislation, and even when a power appropriately exists and may be applied, there seems to be some uncertainty, and as part of the reconciling of powers and tools, we may have to look urgently at creating that, even in the context of other reform measures that we're looking at.
In this context, you look at new legislation or amending, consequential amendment to any other piece of legislation. AGM, so that we have to create, we'll be adding it to existing legislation, or we look at new legislation to ensure.
Chairman, there is a proposal on the table that is being considered in respect of regular policing powers, special policing powers, enhanced measures. A closer look can be had within that context if that is one way to go. Another option would be to look at existing pieces of legislation, including the JCF, the Constabulary Force Act, which I know is far advanced for a repeal and replace. But within that, we currently have context that we can look at to see where would be the more appropriate place.
Minister, I would suggest you look at a completely new piece of legislation. It might warrant, as part of that bill to bring in new legislation, repealing the hodgepodge of sections that might touch on the area. But particularly since have multiple law enforcement and investigative agencies, amending the JCF Act may not be sufficient. You want something that would apply to the work that MOCA is doing, FID is doing, RPD, customs, and there's a number of new pieces of legislation that give the powers of a constable, might also need these need to be covered by this new piece of surveillance legislation. And intelligence collection has become so much more sophisticated with the development of technology, etc., that I think it is very important, even to ensure that we protect the rights to privacy of the average citizen, that such a piece of legislation is developed, particularly given the billions that you are going to be spending on cybersecurity. Israeli companies that don't necessarily have a strong track record of observing human rights.
That advises me on how to spend money.
So I can give you private advice on suggestions on how to proceed with that. It is a real concern that persons familiar with security and law enforcement matters, and particularly because a lot of this is not necessarily evidentiary, and therefore, may not be covered by the existing rules of, evidence and all of that. So I would really say that we want a new, modern, comprehensive piece of legislation that covers both intelligence collection, which may never be used for court purposes, but for the whole gamut of reasons, national security reasons, would be important to collect and to do surveillance on in a number of areas, and then also to cover what is intelligence that will be converted to evidence and used in the court process.
Thank you. I think we'll take note and look at how fast it can be done, because I think the concern here with Belmins is that, of course, getting individuals, whether by infiltration or just by serving into gangs, is critical to getting the intelligence is crucial, but doing it is because gangs tend to be very community-based, and once they know who is involved or what's involved, the retaliation is always severe. So I think definitely we need the total coverage to both protect the officers involved, but also ensure that their methods used governed by a strong legal framework, that they don't involve invading people's, average citizens' private lives. All right, so the recommendations, we look at a new piece of legislation to cover all of this quickly. AG, timing.
Yeah, I mean, there is one point. Well, if you go through the specific points raised by the ministry, and this section is dealing with trial procedure, and they are suggesting that witnesses be allowed to use their pseudonyms. That is the full name that they use undercover to protect their identities. What the section currently allows is that for the court to make a direction in a case under this act in the interest of administration of justice, public safety, public order, or public morality, a number of things. And the court may direct that the identity of any person, including a witness in the case, shall be protected in a manner specified by the court. So that would allow the court, for example, to direct that this particular witness should be known as Mr. X or whatever the pseudonym is. The second thing is the court may direct that in relation to any witness called or appearing before the court, the name, identity, and address of the witness and other particulars concerning the witness, as in the opinion of the court, shall be kept confidential, shall not be published. So the court can direct that there be no media coverage of those details about the witness, the identity, and so on. And thirdly, the court can direct that no particulars of the trial, other than the name of the accused, the offense charged, and the verdict and sentences, shall be published without the prior written approval of the court. So this is a provision that essentially allows for in-camera type proceedings. It also allows protection of identity of persons, including witnesses, in a flexible manner specified by the court. It doesn't make any specific reference to the use of suit, but that would be, I think, a matter for the police if they felt this was necessary, to work with the prosecutors to make an application and persuade the court in a given case. So I think this is already permitted by what we have. Whether it's being used or not is another matter. Yeah.
Yeah, AG.
Chairman, looking at the recommendation, it does give the impression that there isn't an understanding of how the court process is, because the provision that exists in the law would be applied practically by taking stock of the particular case and the sensitivities of the witnesses, and then making an part of managing the process for certain orders. And then you can request particular type of order depending on what you're seeking to protect justice. So looking at the proposal from the ministry, it does seem as if there isn't a full understanding of how the existing provision can work and the breadth and scope of it. Because once the law provides for the protection identity of a witness in a manner specified, then you would proceed by way of an application, and then you can propose to the court an appropriate specification, whether it's going to be by the use of a pseudonym, whether they'll give the evidence remotely behind a screen, or any of the native options that now exist, not only in our jurisdiction but across other jurisdictions. So the proposal for disclosure of true identity, location, etc., all of those can be done in a proper application, but it requires management of the case and understanding ahead of time what you're dealing with, so that those applications can be made. And by the time you come to trial, you would know exactly how the trial is going to be proceeded with, and nobody's taken by surprise. But of course, we can always tidy up and make it a little more specific, so you can give
what the AG and the member is telling me is that when we pass these laws, we should maybe have a full orientation session with especially
definitely
officers who are specifically involved.
There's a lot of training required.
Chairman, that used to be the case. Certainly when I came to the public bar at the office of the DPP, that used to be the case, standardly. Not sure what is happening, no.
Well, I know National Integrity Action does assist, and the USAID funds training programs for persons in the law enforcement and justice sector.
They allow me some of my money to be spent as well, I'm sure.
The other point I wanted to make
go ahead.
I'm sorry, Mr. Chairman. If I may, I
well, Mocha has a point in here, but we don't reach there yet.
I wanted to comment on the current issue being discussed.
Yeah.
There is a more basic issue that needs to be resolved. Currently, there are no provisions in relation to disclosure which allow for a trial to proceed with a witness using a pseudonym. At approximate time to the commencement of the trial, you have to make a disclosure as prosecutor of the witness statements bearing the correct name of the witness. So the recommendations, as I understand them, are more viewed to protecting the identity of the witness in the course of the trial. Before the trial commences, due to that lacuna, the identity of the witness will have to be disclosed. So I think that issue, even if it is dealt with specific to anti-gang cases, but it's still of some concern.
You mean in terms of the prosecution sharing witness statements with the defense counsel?
Yes, sir. What I understand currently obtains for the anti-gang matters going on now is that these are served along with other material, but sometime very close to the commencement of the trial, the prosecution has to serve the witness bearing the correct name of the witnesses. And so inadvertently, the very issue we are trying to safeguard, the identity of the witnesses, has to be disclosed. So I just wanted to bring that to the committee's attention.
Chairman, on a reading of the provision, And again, it does appear that they're not understanding what is available to them. Section 17.2 speaks broadly to, in the interest of the administration of justice, public safety, public order, morality. A court hearing a case in the exercise of its jurisdiction may direct that the identity of any person, including a witness in the case, shall be protected in the manner specified. That is broader than subclause B, which says in appearing before the court. Witness called or appearing. So the stages prior to the commencement of the trial could be covered in 2A.
Maybe the marginal note is a bit misleading, because the marginal note which says trial procedure really relates to 17.1 primarily, whereas, or maybe it's too narrow rather than misleading, because 2A is a broad jurisdiction to protect identities of persons. It's not limited on the face of it to what's happening during the trial.
But I think it could be clarified to specify, including at the disclosure stage. But I can't, I mean, I'm just a little befuddled that persons wouldn't understand that at different stages of your proceedings, you can utilize provisions. I mean, it smacks of, let me not say, seriously? I mean, goodness.
Well,
but
if it's a real issue, it's a real issue.
It can be clarified
Yeah.
to include at any, at whatever
that
stage.
The law already covers, provides the facility to not to disclose the identity of witnesses. Is that what you're
what Mr. Park is saying is that in practice, there is an obligation, or they're treated as having an obligation
Does the
to
law allow you
disclose
to
the actual
change that
name,
practice?
actual name of the witnesses who gave their witness statements at some point prior to the trial, which effectively exposes those witnesses.
From
and
the AG that the law allowed to apply the change.
7.2a is wide enough to allow, in case management, the court, if an appropriate application is made, to ensure that that doesn't happen through some redaction or some other method that would preclude that. But there's nothing specific saying that here. It's just the words are wide enough to allow it, but there's no specific reference to that. So I think the AG was saying it could be clarified. Yeah.
I take the AG's point that a suitable application could be made prior to the commencement of a trial, but I think the issue is not only limited to anti-gang cases. There are other serious offenses where a similar protection may be necessary for witnesses.
That's right, and that's actually where I was going, because if you look at the third point made by the ministry, they're talking about 17.2a should be amended to extend special measures like voice modification, giving evidence behind a screen, and so on. And again, I mean, there is a Evidence Special Measures Act that deals with a particular set of special measures and applies to all offenses if the application is made. I don't know whether given the point that Mr. Parker's made, that this need to protect witnesses in this way should not be limited to this thing. Maybe, yes, you need to consider something broader.
Advise me, AG, before you come in, advise me. But what I'm picking up here, that the current legislation is broad enough to get protection for witnesses in the Anti-Gang Act. But you're saying that we maybe need to look not at anti-gang, but at legislation to protect it on a broader basis. All right?
Chair, through you. In relation to this provision, from the ministry's point of view, this came about as a result of consultation with the DPP's office. Certain challenges when the applications are made based from a constitutional point of view, where the offender has a right to know, as well as from the Evidence Act point of view, where they're saying that the interpretation of the courts in relation to that act and in application to this section doesn't allow them the range of measures that they're asking for, and that is the reason why they're asking for it to be placed.
They didn't put that in their submission, rather than having it indirectly through the ministry.
I was about to ask if we have any data on the on applications made prior to the actual hearing, and those applications were denied, because at least it would give some indication. And we can't continue to revise and make anecdotally without data. I mean, I find it extremely unacceptable that given the provision and the request, and as the member said, an application, the DPP's input was made, that hasn't come. When you look on what is provided for, do we know, I mean, by way of data, how many applications have been made for the protection of witness identity at a stage prior to the actual hearing, and those were denied, and for what reason were they denied?
If I may, Chairman, I recall that the DPP did in fact refer to proposals that they had made in relation to the topic, that the subject of witness anonymity and legislative provision. They made several suggestions, and my understanding is that is being considered at this point.
So witness anonymity on a general basis.
Yes.
Yeah.
Yes,
Specific case. So it's Minister.
Chairman, clearly there is need to look in a general way at the conduct of trials and what takes place at different stage, from the time the indictment is preferred or even before, from the time the charge is laid and persons are brought before it, right until the trial is completed, verdict is entered, and if sentence follows. But it would be generally, so that one is not guessing and spelling whether it applies only to a particular set of charges or not, but they would be general to the conduct of criminal proceedings.
I do recall the DPP raising the issue of witness anonymity and legislation to come from, but if I get you, you're saying that there is enough in the current legislation to protect the witnesses in these cases. Am I right, members?
Chairman, it does appear that where we are going is to do a little tweaking of the section, including the marginal note, and I mean the marginal note is not what really you go by to interpret, it's really just a guide. Yeah, and if there is inconsistency between, I understand, if there is inconsistency between the marginal note and what is provided for in the section, then clearly what is provided for in the section, and we have a lot of case law on that. But there, I guess, can be harm in using some words to indicate that the application can be made prior to the commencement of the trial or at the stage of disclosure, something to that effect.
Minor changes here, and then the bigger problem of witness anonymity be brought in a different legislation. Thank you. There's a reference here to immunity for those who come forward to provide information. Do you have any comment on that for the ministry? The same section 17(2)(a).
I read that, and I must say I'm a little perplexed by the idea that we're trying to give statutory immunity.
Is this some kind of plea bargaining?
Well, there are two different issues. The plea bargaining, I think, is kind of relevant to the last paragraph in that column on page 16. But in relation to the penultimate paragraph, what is being advocated here is a statutory exemption from civil liability for things done in good faith by officers, surveillance officers. It says officers, but it means officers, yeah. And, from time to time in legislation, we give public officers in certain institutions who this kind of immunity, but in relation to police officers who are out there on the ground, and given the nature of the relationship between the JCF and the population, I think that any attempt to exempt them from civil liability for, say, negligence or something of that kind, I don't think that would wash.
To say, Chairman, that liable persons who are involved in whose conduct is impugned, not giving the defense and not having giving proper instructions, keeping their record, and even where immunity is provided for, inquired into. So it's not inquired into. Yes. So without more, I think the focus is wrong direction, and we keep legislating and we don't get the solution. So persons who are utilizing tools, especially if Where procedures are set out, those procedures must be followed and they must be documented. Actions are not usually brought in the heat of the moment. And, with the passage of time within the limitation period on the civil side, instructions must be provided in detail to answer claims that are made. And I think that is more seeing through the lens of the chambers. The bigger challenge when claims are filed is getting instructions from persons whose actions are called into question, and it shows their own approach to the exercise of powers granted. And I think that's where we need to focus.
I just don't think it would be acceptable to Parliament to grant civil immunity to police officers interacting with the public in how they operate. So, if abusive conduct is a problem, or it's certainly perceived to be one. So I think to grant some kind of civil immunity for that, or conduct that gives rise to a claim, to my mind, that's the wrong. What we need to do is to improve the behavior and their capacity to deal with difficult situations.
Clear from my colleagues,
yes,
both sides. What of the question of immunity to witnesses or members who come forward now to convey information? It sounds like
I thought that was that we have plea bargaining legislation that can lead to a plea agreement, which could give you immunity as part of that, I believe.
Have a criminous participant giving evidence, the Director of Public Prosecution to decide whether, in exchange for the evidence to be provided, any charge would be preferred. I'm not sure if that is what you're going at in terms of the protection of witnesses. Because persons who are part of the gang culture, the victims themselves may be victims and we part of the gang culture. And sometimes the only way to penetrate it is to get the information from someone who is a part of it. And in exchange for the giving, the criminal justice system is replete with examples of that. It wouldn't be unique to Jamaica. And it's the case that is now before the court. That isn't the first example of it. And that has always been understood. And again, we have many examples where in exchange, in fact, even when persons are charged jointly, depending on the statements and depositions that are available, in practice, persons in exchange for entering a nolle prosequi or discontinuing the evidence on the other side, and then the quality of the evidence would be subject to the warnings that the court is required to give if person has an interest to serve and is then going to seek to exculpate himself from activities that he was a part of.
In case, as a member of the gang, as a witness, he has been, and he'll not be charged. Is that what you're saying? The current law provides that I've heard discussion at layman about the need for plea bargaining legislation in dealing with gangs.
We have that. We have plea bargaining legislation, and it was just we've had it for a while. What was there and brought in a new one, but I'm not sure, for example, whether that would apply to in an investigative phase where you're trying to get somebody to crown witness, whether you can grant them immunity at that stage. My recollection is that it has to be through the court system and a plea agreement which is blessed by a judge.
I need clarification. Okay, it's important in dealing with gangs. The surest way to get any kind of quality evidence is to have a gang member turning. And I know that has been raised on many occasions. Outside of that, it's extremely difficult given the social structure of gangs. They come from communities, they know each other, and it's very difficult to penetrate them. So if you can get a gang member to turn based on immunity is a critical point. I just need to know it. Does the law currently allow for it, or the request here by the ministry is critical to it? Or we need to amend the law to make it easier, as you're suggesting?
Chairman, currently, police officers who are investigating crimes do have a discretion as to who they ultimately charge, and of course they are expected to justify it. And if in the process of investigation you come upon someone who could be charged but is of greater value as a witness, there has been nothing in the law that prevent them from using that person as a witness instead of charging them. And also, I mean, I think some of the suggestions speak to the culture. If you're investigating, you keep as open a mind as possible. You don't determine ahead of time who is to be charged, because in so doing you might eliminate a real suspect.
I hear you.
It's a culture.
Let me ask another question. I have to be as a provocative in this day. The police arrested a member of a gang, for a particular act. He was not necessarily part of an investigation in the gang. Having decided that I can, and they identified or realize he's a member of Django's gang, and he's going to give you all the requisite information now to really close the case on the entire gang. But he was arrested for this. You say now the police is free to drop that charge or not proceed with the charge? Always. Okay.
But there's no formal procedure that I'm aware of that would apply there. To just be there would be some kind of agreement that the police are going to say, well, we will not proceed against you if you give evidence against it to get to. But there's no, unlike the plea bargaining situation where you have a formal agreement which gives you certain rights, which is blessed by the court. It's a more informal thing.
Should it therefore be regulated to statute? I take it, first and then come back to AG.
Stand your example. Because you spoke to that charge, and from how you spoke, I formed the view that a charge had not yet been preferred. And we got to be very specific about it. Dropping a charge and not pursuing a charge are two different things arising at different stages. So I'm not sure what it is that you want to have happen.
AG is coming, but both comments apply. One, the officer arrests and charges John Doe for having charged him. John Doe, having realized he was charged now, is willing to begin to give information that is of quality evidence, as well as arresting the other John Doe just because with the intention to tip. Having brought him in and identified him, identify him as realized he's a member of the gang, and in discussions, he then decides he will provide the required evidence, so he don't pursue the charge. But what this is the case, what I'm interpreting the comments here, that whatever stage of the game you have, John, he decides to give you quality evidence that will be able to lock down this gang of 15 homicidal characters. He can be made immune to prosecution. And the exact legal language, but he gets off. No charges preferred against him or pursued against him.
As I understand it,
asking, does the law currently provide for that, or is it something that is needed to be, whether by amendment or addition to this legislation, makes sense? The information, what I was getting from my colleagues here, is that the law currently provides for that.
That is my understanding, because from the procedure, the investigating officer has a discretion whether to prosecute
AG was
or not. And if prosecuted, then the plea bargaining could apply. So I don't know if we are trying to provide for that which exists, or we're trying to provide for something that we think we need. seems to me to be more so the former than the latter.
What was the origin, Chair, of this
I think
particular
AG,
recommendation?
let me tell you, member.
Huh?
AG, then yourself. Okay.
Sorry, I'm sorry. No, I was just asking what was the origin of this particular proposal from the minister? Where is it coming from? What was the experience that informed it?
So in putting together the proposals, we would have had working group discussions with members of the JCF, MOCA, JDF, and they would have highlighted certain areas that this was one of the areas that was put forward. So a proposal for immunity framework for witnesses, so that in investigating criminal organization, depending on the value of the evidence, then they would be granted immunity.
Just a simple inquiry. Who would grant that immunity? What was contemplated?
All right, so the granting of the immunity, ideally, what we were envisioning is that the DPP would grant that immunity.
There's appear confusion among the officers as to what they can and cannot do when the law empowers them to take action, whether by way of surveillance or otherwise. My initial understanding of the proposal, starting at page 15 in respect of section 2, the recommendation, I think, having gone through the discussion, is to clarify in the law that an application can be made to disguise the identity of the witness ahead of the actual trial, and that you'd set out and the court would. So that even though it can be accommodated under the law, you want some clarification. The second part of it about the immunity for witnesses, you're talking about non-civilian witnesses who are empowered to do certain things. And you're asking that in exercising those powers, they should be granted immunity. Because if that we're proposing the inclusion of a provision to grant immunity to persons who come forward to provide information that can be used to dismantle a gang, if that proposal relates to non-civilian witnesses, then it begs the question as to whether the person coming forward is involved in the gang activities. You must, that is why I asked a clarifying question ahead. Who is to be granted the immunity? If these are non-civilian witnesses, it would be the duty of the police officer, if they have information, to investigate the crime, bring forward the information they have. Why would they need immunity in those circumstances? Unless I'm not understanding.
So if I may try to clarify, it's not only for non-civilian witnesses, it's for civilian witnesses as well, because we had put forward the surveillance officer and the different immunities, civil immunities to be granted for the surveillance officer, but to also allow for protection witnesses and not allow for these witnesses to come forward and more freely give information. We propose the immunity framework for them as well.
You know, Mr. Chairman, I think, this is my third straight day of committee meetings, plus we had a very long session of Parliament into night, really. It would be much more efficient for us parliamentarians, various government agencies and departments would review these by themselves rather than using a parliamentary committee time where we just sit here as observers while they try and sort out their understandings between themselves. It's about time. I don't mind committing my time, but I dislike wasting my time. I dislike using it inefficiently. So perhaps some of these issues could be resolved within the executive, so that when we get the disparate presentations, they've already been synthesized internally, and the AG would have,
a common position.
already filtered the various requests, or the AG's department would have already filtered the various requests, and informed the ones where there was confusion. But for us to sit here as observers and go through this is a really inefficient use of parliamentary committee time. So may I suggest, yeah, so it would be good that when we come here, we understand what the executive is trying to achieve, and they understand it also, and then we could proceed much more efficiently.
Some of these matters are properly issues for law reform to look at, and I suppose I think you raise an issue. You raise a real issue, because what is emerging is showing up some things. Maybe this is not the forum in which to speak about it, but
you can't just leave it at that, because some of these issues are for the AG to look at, because there are constitutional issues raised. So that the suggestion made by you are being mischievous? Me? Oh no. The suggestion made by Mr. Bunting seems to be a reasonable one.
I was about to say, remember, that's not unreasonable. We'll see how that can be dealt with, right?
Yeah.
But coming through in this discussion, I think there are two things for this section without prolonging it. One, in terms of witness protection, we should look at a new piece of legislation for the surveillance officers, new legislation dealing with information intelligence gathering. And two, it would seem to me from the discussion, despite of differences, that you can in fact pursue, you can apply in court for the protection of the witnesses as necessary, and you can decide not to pursue prosecution of critical witnesses, whether at the level of the investigating officer who gets the information early, or even when it reaches to the DPP's office. Am I wrong in that?
But I think the idea of
clarifying
that how the 17(2)A power can be used.
But we agreed to that before.
For example, redaction of names from statements.
Yes, we have agreed to that, I think.
Yeah. Those are important issues in practice.
The clarification on 17(2), particularly, and that's primarily what would come out of this contribution here. I still have the
MOCA.
Remember the AG and the others. MOCA made a further.
Yeah, they want to make it mandatory. They're suggesting here that a mandatory application be made by the Crown, or initiated by the court. In the column, in the MOCA column.
Couldn't be mandatory. I mean, you just have to provide for it to be done.
16.
And on a case-by-case basis, you would make the assessment.
Look at the top.
Because you still would have to satisfy the court that it is in the interest of just to grant the application that is being asked for.
I think that is an internal matter for MOCA and the DPP's office to operationalize, that you will routinely in these cases make these applications. I don't think you can make it a legislative thing to say that it must be made. It's up to you whether to make it. You have
what I see emerging here in this section is that the law enforcement, the agency looking at treating the gang thing, the party, and bringing matters that can be done by existing statute to another level. I take the advice of my colleagues, so, and pursue, as said, clarify 17(2)A, and then we necessarily a new legislation, look at the new legislation you're asking for in other areas. propose an increase in fines. Any object? Current fines is $1 million. Proposed increase to $3 million, and
What is the rationale for the proposed
And
increase
3
from the
years.
Ministry of National Security? What is the rationale? And how?
as indicated, they do suspect.
What example, what data do we have to show that how has it been used, whether it has been a sufficient deterrent or not? What was the data? And what really informs the proposal for increase? But you know, Chairman, doesn't matter how heavy a penalty is, you only get to it after you have successfully investigated, charged, and prosecuted someone.
But in any event, the provision provides for an unlimited fine in the circuit court.
There you go.
So, I
That's
mean,
what I'm asking.
4A talks about in the parish court, where it's a $1 million fine cap. But in the circuit court, it's unlimited. Yeah.
A court of unlimited jurisdiction. But
And the way the provision is worded
right.
is...
It allows for trial in either jurisdiction, but if you try it in the parish court jurisdiction, then it would have to have regard to the jurisdictional limit. But I notice, Chairman, and I just highlight by way of example, to show there isn't sufficient understanding of something. I go back to page 2, proposal from National Security that the definition be amended to replace resident magistrate court with parish court. And it is also reflected here. But when the Judicature Parish Resident Magistrate Court Act was amended for change of name, there was a section which tells you that there is a consequential amendment, and anywhere the name resident magistrate appears, it shall be read and construed as parish court. And when I see these, it really tells me that legal officers don't understand, because it's not possible to amend every single piece of legislation at the time, and that is why you do a general provision. And if you understand that, then some of these things wouldn't be coming up again.
But recommendation came from whom?
National Security.
But national security is made up of other than legal officers. So be careful. The legal officer may be presenting the situation, but
Member
I wouldn't be so blanket.
I'm not knocking really, but you should know, for having served in that portfolio, that all matters relating to legislative proposal from a portfolio ministry should go through the lens, be vetted by the legal officer, and then it is passed on to the chambers. That is the process.
Well, then you have to zero in on the Ministry of National Security, not legal officers, because the persons in drafting CPC, they are legal officers. And law reform. No. We have a tendency. And I'm one. I've always fought against that tendency.
Are we on page 19 now then? Because
That's
everything
why
else
they say
seems to be no
politicians,
change.
that they are thieves. I'm a politician, but I'm neither damned nor a thief.
And these are new provisions to be included in the Act. This is important. Yeah.
We're on to page 19 now.
Yeah. So, colleagues, we're now moving to page 19, which is dealing with proposals for new provisions to be included in the Act. 19. So the first one is from MOCA, saying that there should be a specific recognition and enhanced penalties for law enforcement personnel who are proven to be members of a criminal organization or are actively committing the offenses prescribed under the Act. I don't know why that's headed tipping. That's not a tipping off offense. It could be, but it's not limited to that. The case can readily be made with regard to law enforcement personnel who tip off criminal organizations operating in particular communities of impending law enforcement deployments, move weapons and ammunition, carry out extrajudicial killings. All these are covered by it, at the behest of criminal actors, and even engage in gunfights against their colleagues due to their allegiance to criminal gangs. This is real. This is real. There are policemen who live in communities and get involved in these things. And the proposal from MOCA is that there should be recognition and enhanced penalties for law enforcement personnel who are proven to be members of a criminal organization or are actively committing the offenses prescribed under the Act. Is there a tipping off offense in this Act? No.
But there must be law that would create an offense for tipping off. I imagine for police officers in particular who tip off criminals about investigations or about operations. That must be an offense.
The only one I can immediately call is the tipping off offense in poker, but I'm not aware of any other tipping off offense in criminal legislation generally.
So there's nothing in the jail, for example, that would make an offense for an officer to tell a criminal that there's an operation coming for them.
No, sir.
I guess when the Act was written, it was never conceived that that was possible.
It was never.
Wouldn't there be some common law offense that would cover it?
It might be an accessory.
Yeah, wouldn't that make you? Yes, an accessory.
Would it be perverting the course of justice?
Possibly. But again,
because I have known of at least one case from Westmoreland where a police officer did that and was charged and convicted. I can't remember what the charge was charged and convicted for it and did not succeed on appeal.
But
yes, sir, but
remember, the fact that MOCA has raised this as a problem, I think we should have a direct solution for it. Personally, I think that there ought to be something and it shouldn't be limited to the gang legislation either.
No, I was going to say maybe it could be an aggravating factor. The fact that a person is a member of law enforcement would be an aggravating factor in considering a penalty for them of a gang or committing any of these offenses in the anti-gang legislation. But I would think the offense, however we're going to style the tipping off offense, must be something that is generally applied across all law enforcement, not even just JCF. It should apply to, in fact, it probably should apply generally. I'm not even sure it should be limited to law enforcement. But the learned counsel to my right is saying he thinks that's what perverting the course of justice.
That's a very broad concept, isn't it? Yeah. Perverting the course of justice. This could be one example of it.
So I think in the context of the sort of focus that we're placing on gang activities and wanting to stymie or stop those activities, a standalone provision in these circumstances, I think would have greater value. And perhaps, if I could make a second comment, it might be our fault in terms of expressing, but we're making two separate points. One, we felt there should be an enhanced penalty for law enforcement members who are found to be involved in gang activities, and then a separate offense should be the creation of a tipping off offense. And I would support the member who was suggesting that it should be broader than this, because, for example, you can readily see where it's applicable for corrections officers, where if a search is being conducted of a section of a prison and they alert persons with contraband prior to the search. So it's
who they may have supplied it to.
Yes. So they have an interest to serve.
So, Mr. Chairman.
I don't quite understand. I don't quite understand the idea of the sentence of the sentence that I don't quite understand it. Because we set a maximum sentence for breaching a particular section. And then the judge determines what is the appropriate sentence. And I'm aware that judges do take into consideration in applying the sentence that they think applicable, the status of the convict. And where the convicts happen to be, for example, policemen, judges specifically say that because of the nature of your office and you have committed this offense, your punishment is X years, and if there is a co-accused who is not such an officer. So I don't know how you intend to achieve that which you say you would like. Is it, for example, that you're saying if it is a police officer, for example, then the sentence, the maximum is not 30 years, it's 35? I don't know. How do you intend?
It could be manifested in that way, sir. What I understand is that this Parliament, in passing legislation, in some way internalizes concerns of the public, and it recognizes mischiefs that need to be addressed. And we are merely raising this as something which is readily recognized by members of the public in terms of the involvement of law enforcement personnel as an indication to the public that yes, we appreciate this reality, and this is a part of our response to treat with it.
If the courts already recognize that and say so when passing sentence, that's for public consumption. So I don't think that merely legislating here would change that which now exists. It would have to be that you are dictating to the court that so long as the person is a police officer, he must. And I think you might run into some difficulty because sentencing, the executive has the jurisdiction and the legislature to set a maximum. But I think that the prerogative of sentencing, that which ought to be applicable, having
I don't
regard
think they're proposing
to the involvement,
Yeah,
is that of the court. So I'm not sure.
I think what I understand Mr. Park to be saying is that similar to how we treat, for example, the recruitment of a child to a criminal organization, where the maximum penalty should not exceed 20 years. However, if the offense is committed within 300 meters of a school or other educational institution, that ceiling increases by an additional term not exceeding 10 years. Yeah, so I'm just asking him if what he's suggesting is that we're, for example, forming or establishing a criminal organization would have a penalty on conviction to imprisonment for a term not exceeding 25 years, where this person was a member of law enforcement,
Our
you
government.
might increase that by a further 10 years, for example.
the maximum.
That's what I asked him, if the intent was to set a higher ceiling for police officers.
To remind colleagues, the comment from in committee, it was agreed that given a problem of corruption, that the suggestion have merit. applied across both the security personnel and other personnel who may have enough information in government. If you read and what the member was saying, I've raised the issue that we should say exactly what we mean. There's two points here from the Joint Select Committee. One, we need to be specific as to who we are referring to. Two, given the problem of corruption in Jamaica and the fact that it was known that prominent persons or persons in position of power and influence do have less than wholesome association with criminal elements, there was merit to having this as an aggravating feature. So basically, you're saying for those who have position of influence, whatever the maximum penalty is, there would be an increase, an aggravating factor, another 10 years or whatever.
Well, then it should be applicable to other persons.
Well, that's what I said here.
No, I'm saying that you should specifically include a legislator.
Police, you're suggesting, member Knight, that you should say law enforcement officers, legislators, and
municipal officers.
Target, identify. Okay.
I'm talking about. I'm not talking about necessarily no. In the municipal services. I'm talking about the councillor. I'm talking in the legislature, talking about the MP who sits in the lower house, and I'm talking about the senator who sits in the upper house. That my proposal would be
it's not in here now.
That the court be given unlimited jurisdiction to send them to prison.
There's any problem to try, but what you have to do is make sure you cover all the areas of position of power and influence. If you are being specific, although given the earlier discussion, there are times when we tend to adopt the general law, but I think in this case, there's good reason to be specific. I wouldn't have a problem with that.
In this case,
AG.
In this case, because you have legislators. What it says, the case. About who are tied to criminal organizations, themselves being criminals, and they associate openly with criminals, and then they are legislating. Some of them are downright out common thieves.
The comment on page 20 was more specific, remember? Any public servant, whether someone operating in customs or police, security forces, judiciary, legal, political, directorate, then there would have to be some specific mention, and that within the Act, police officers should not be the only ones singled out, and therefore it apply to any public servant who would come under the purview of the Corruption Prevention Act. So the committee did indicate that it should be more specific.
For a greater penalty where the offender falls within a particular category, including a police officer, finds favor with me. The further suggestion, members of the political directorate, because we had that definition elsewhere, which also finds favor with me if we are serious about breaking the gang culture. The recommendation for a specific offense of tipping off in this context finds favor with me, looking at it more broadly in certain areas.
Chairman, if I may, I would ask that justices of the peace be included, because my understanding is that the definition of public servant does not include justices of the peace. And where, for example, you have a JP providing a recommendation to a gangster to get a licensed firearm, then certainly in those circumstances, because the JP in giving the recommendation will say, I know this person personally for X years, would suggest or should suggest that he or she is aware of the activities of the person. So in that context, you can't say you know the person and claim
I
not
think
to.
the point is well
yes,
made.
very well, sir.
Okay. So we take note and ensure that in the additional clause we cover all the areas, and it will come back, of course, to us for final approval. And it will go through AG and come back to Parliament before we pass it.
You know, Chairman, this thought has occurred to me. A distinction between a senator, an MP, and a minister, because the minister is a part of a body that constitutionally is the highest policy-making body in the country. And a minister is a part of a body without which no legislation could come to Parliament, save by a backbencher who private members bill. And if we're really serious, and we want to send this message which Mr. Park has so eloquently articulated, and with which I strongly agree, would make these demarcations, and one gets to that high political office and transgresses the law in a corrupt way, and I use corrupt in the sense of dishonesty, because sometimes corrupt can just be abuse of power, in terms of dishonesty and involvement in other types of criminal activity. That person, the highest possible sentence that a constitution allows, which is life imprisonment and without parole. Without parole, because the society should be safeguarded from such a miscreant, such a rogue, such a despicable character, creep. That's what should happen. And I commend it for consideration.
You're suggesting, therefore, that we should define the members of the political directorate and have different aggravating.
It's not difficult to,
No.
Any member of Parliament, any member of the Senate, and any member of any municipal
Any
corporation.
member of the cabinet.
That covers all elected representatives.
But I'm saying,
I'm suggesting you have member of the municipal council, member of Parliament, mayors, and members of the cabinet.
Mayors are already covered.
covered by that.
Members of the cabinet and mayors are already covered by the other three.
No, they're covered by definition. No, the member is suggesting that you have special penalties for those who carry additional executive responsibility. Right?
What are you suggesting?
They are clearly defined. It's whether it's proposing that those members who have executive responsibility be in a separate category from those who only have legislative responsibility. Was accepted.
You included justices of the peace in that? Huh?
Yeah, including justice of the peace.
Yeah.
Definition of surveillance officers. This is
again, I don't think that is specific to this piece of legislation. That's one of the
that was
more general. We had agreed it was going to be treated in a more general. So, Mr. Chairman, in the interest of completing this, I had made a suggestion at an earlier meeting that we don't delay our considering the amendments or the suggested amendments that would be unconnected to this, since this committee is really reviewing the Criminal Justice Suppression of Criminal Organizations Act. That when peripheral recommendations come up, and we recognize them as not amendments within this specific act, that we noted them in our report, refer them to, Mr. Bailey's unit, or wherever the relevant agency or department is in government, and we focus on specific to the anti-gang legislation so that we can bring our report to Parliament and make our recommendations for the specific amendments there. What we have covered so far really doesn't suggest to me any major defects in the legislation. I mean, enhancements, but what it points to, I think, more than even any particular defect, is that perhaps more training should be done of our investigators and our various, relevant departments in law enforcement who need, how to properly utilize this as these new set of offenses in law enforcement.
AJ want to comment, but I bear in mind your comment. But I think the first step cases are done to court now. I think maybe the review was a bit early, premature. Because there might be things to be done, but I don't think. In addition to training, we need to see some of the activities tested in court, and therefore you can have a stronger base on which to look or review at aspects of this law.
Well, I don't think there's anything that says it has to be a once and for all review.
No harm being done for looking at it anyway.
But I think if we keep stretching out this review process, I mean, waiting for new case law or case experience to inform it, I mean, it will be in perpetual session. So I think, just my session to you as chairman, that will bracket those that really are not going to involve specific amendments to this, and push along so we can complete the report, which is really about a review of this act, and then the AG's department, the law reform, the Ministry of National Security can continue parallel work that doesn't require the legislators to be involved.
AG?
I'd crave your indulgence to just go back to the definition of criminal organization, and I'd like to put a proposal for consideration, essentially using the same words that are there, but just to rearrange them a little. So currently, the definition of criminal organization is that it means any gang, group, alliance, network, combination, or other arrangement among 3 or more persons, whether formally or informally affiliated or organized, or whether or not operating through one or more bodies, corporate or other association that has as one of purposes the commission of one or more serious offenses, or in relation to which the persons who are part thereof or participate therein, individually, jointly, or collectively issue threats or engage in violent conduct to create fear, intimidate, exert power, or gain influence in communities or over other persons. I'm just wondering, and again, this is based on some of the comments I had heard, though not all of those comments came in formally, if we probably could look at it as meaning any association among 3 or more persons, whether formally or informally affiliated or organized. Using again the same words, but just rearranging them so that the need to prove that you're a gang or an alliance would not necessarily arise. And also the commission of one or more serious offense. There are a number of minor offenses in relation to public order where these gang members or groups are affiliated with, whether it's the solid waste management, but is designed to facilitate the carrying out of their offenses. whether it's necessary to have the serious offenses.
I was wondering if this was a convenient time.
At least.
Well, it's just a matter of rearranging the words for criminal organization and consider whether the serious offense, given the reality of how these criminal groups.
Serious offense is a defined term, but it makes reference to a schedule.
Right, I know.
Which is a very extensive schedule.
I know.
And then the minister can amend it by order, subject to affirmative resolution. He can add, if there's a particular sand mining offense that is involved in, and that might be there already, by the way, but if there's some particular activity that gangs are involved in, which are not included, in this, it's easy enough to add it.
Examine the schedule and see to what extent we can.
If there are any gaps.
We take note of that.
Yeah, and
Okay,
on the
thank
issue
you.
of rearranging the wording of the section, of the definition, which is core to the whole thing,
Okay.
I would be really reluctant to do that until after the current matters that are
Okay.
finalized, because
We will.
I don't want to create any kind of legal jeopardy around that.
Say though, and I understand the reluctance, but the persons who are being charged would have to be charged on the law as it stood at the time. So this is not going to, but it is an issue that was raised, and like I say, I didn't see it come back about the need to prove the gang. It's just how it is phrased, It's not, the concept remains the same, but it's the actual wording of it.
We had, on page 21, I had skipped over item 10, which I gather is a very...
Well, it says gang, group, alliance, network, combination, or other arrangement among 3 or more persons. It's the widest possible listing of. Well, I don't know. I think that you're implying once you start to tinker with it here, you're implying something about it as it stands now, which is what I'm reluctant to make any such implication at this point in time.
Put it no higher than I have put it. Issues were raised about the definition and what is required to be proved. The police did, the JCF did, and
In their
DPP.
submission?
It was raised orally, not in what was
I
written.
don't remember hearing
Yes.
that.
All right. Item, before you go, may just take on the point 10, compelling a suspect hold an electronic device to provide the police access to the device in furtherance of an investigation. That's an amendment to the existing law, I presume. Same page 21. Yeah. And any other electronic
I think
equipment.
that's a general provision.
This is put here as a new provision. 21.
Yeah, I'm just saying I don't think that should be limited to this legislation. About being able to compel a suspect who has an electronic device to provide them access to the device in furtherance of an investigation.
Is to make it an offense. Well, I understand. What is, if you find him on a cell phone and the police ask for the password and he doesn't give him, he's committing an offense. Is that not possible? Is not no? What? This is what from this layman's term.
But is it akin to needing a warrant or something? That's in the same way that you need a warrant to go into a person's house to investigate it, to go into them phone. You know, it's a.
But Chair, I have a strong recollection, rather extensive conversation about this, and that in fact I think it's section 17 of the Cybercrimes Act provides for a regime for doing exactly this, which has to be done by a 17, I think, of the the Cybercrimes Act. Yes, provides for disclosure under court order by a warrant.
So you don't need to have it here, yes thing. and you need a warrant.
I don't think it can be a facility that applies only here. If you're investigating a murder, if you're investigating a robbery, rape, you know, those tools are available via the court, and that's.
The qualification was important. You must get a court order to do so. If the person refuses,
A warrant.
a warrant.
Yeah. In accordance with Section 17 of the cyber, maybe they need training in that too, but that's the mechanism that should be employed. Is that limited to Cybercrime Act offences, or is that a general provision?
Mr. Bailey, I think member is asking a question here.
No, I was just asking whether the Section 17 provision would apply to all offences, as it were. You know, not just limited to offences under that act. Yeah.
Yes, it does.
All right.
It applies to all electronic equipment currently available and like to be made available.
Everything defined.
Telephones, tablets, laptops. All of them are covered.
All of them. Everything defined as a computer, which is a very, very broad and wide definition.
Okay, so you really don't need that here again. All right. I think everybody getting a little bit page.
What they need to have is a manual, tools available to law enforcement under the law. And you know, if you need to search a cell phone, you can seize the phone, get a warrant from the court, and get an order to allow you to compel somebody to let it in. Yeah. The seizing.
To raise the issue of absent a search warrant or search and seizure provisions. Yes, we did that.
No, we didn't.
Yeah, that's what you're asking.
We did the treatment of non-nationals.
I think the point about non-nationals was a little bit more nuanced. It was a little bit more nuanced than what is appearing here. I think. Exactly, but I think their point was that if somebody comes into the jurisdiction to be involved in gang activity, that ought to be something that's treated as an aggravating feature. So if the man them come from wherever, I don't even want to call any nationality, but somewhere else, to come and embolden or empower people here.
What would you convict him for? If
you would presumably convict them for offense under this act, but it might be an aggravating feature.
May I ask, if he's coming from Central, North, or Caribbean island, as part of a gang that you're investigating and he's arrested here, you lock him up anyway.
Yes.
Now, if he comes to the island, you'd have to prove that he's coming here to do something. No.
You'd have to prove the offense has been committed by him, but I thought the point was that you wrong disincentive. No. Yeah. Well, Mr. Park is here now. Maybe he can explain it. He was a little distracted, so let me just point it out.
The chairman has a different point. The chairman is saying that in the circumstances, the prosecution would have to prove that the purpose for his coming into Jamaica was to be involved in gang activity. Is that what you're saying?
I don't think the thing would be...
That appears to be what is especially if he comes as a member of a gang, whether he's citizen or not, he's locked up under the anti-gang law and will be charged and convicted.
But if a non-national I don't think you need to prove the purpose for which he came. If a non-national here is engaged in gang activity, comes here and is engaged, the fact that he is not a Jamaican and is here doing that should be I thought that was the point. And that's why I asked Mr. what the point is that he was making about in relation to non-nationals and the anti-gang rules.
What it says here, the Act does not, if I read the comment there, the Act does not contemplate the treatment of non-nationals or persons who are lawfully in Jamaica or either convicted of offences on the bill or added to as associate of a gang. But once he is an associate or a member of a gang, it doesn't matter what his citizenship is.
Correct, but I thought the point, they had a point. I think they understood that you know, whether you're from whatever your citizenship is irrelevant.
Intent is difficult to prove.
But I thought there was an issue you wanted to serve as some form of deterrence for persons from outside Jamaica to be involved in it. Can you remember what the point was you were trying to make?
You're correct, sir.
Just before, yes. Look here. Don't take away from the judges that which they already have and are exercising. Don't give to them more than they need. There's a lily. It's a lily. Don't gild it.
Member Golden is correct. The primary reason behind the suggestion was for it to be a deterrent effect, but whilst we have been presenting and the ensuing discussion, the point was very well made that once they're within the jurisdiction, then the court is at liberty to treat them as it would a national. So I think the comment which indicates it's irrelevant is, well, we accept the point. Yeah.
So everybody getting a little bit tight. It's 12:35. On page 22, there are several references to certain Caesar provisions. Can we? Okay. It seems like this will generate some discussion.
Okay.
All right. Yeah, we did the same thing with the electronic. We did that. I agree that it should be done. It probably is covered in cybercrime. Yeah, suggesting that we, and on the next meeting we begin on page 22 with the question of provision for the search evidence to be brought under the Anti-Gang Act. All right? And I would also have discussion that the AG,
how many more meetings of the committee do you think will be required to complete the work?
Well said 3 meetings, 4 meetings, well, including this one. Yeah, today's. Yeah, it's 4. 4 into today. 3 more meetings to cancel on the 16th when I'm traveling on an offshore business. I think we can fit the 16th. Yeah, next week. I think we could, looking at what's here, I'm going to ask that maybe I could ask the team again. There's always, the MNS usually consults with a number of others to ensure that the matters coming up, said, are not matters that will require amendment, suggested one member here. So if they're there, we eliminate them. If we do not too many things here, we should be able to go through the amendments in the next sitting. And the final sitting was designed to have a final look at what all the proposals are when they're put together before we send it back. A report. Yeah. So we can't set that yet. No. All right. Well, we have reserved 2 days, so we keep it 2 days. But one more meeting before the report. Yeah. We have 2 meeting days reserved as a matter of precaution. Okay? But we finish in 1 meeting then. So what's the next date? The 5th of June. 5th of June. Okay. We have the 5th and 16th reserved. Yeah, because we have the 5th and 16th reserved. The 5th at 10 a.m. and both of them at 10 a.m. 12, the 5th and 12th of June. Yeah.
5th of June?
The meeting next week is cancelled. Yeah.
So the next meeting is June 5?
Huh?
June 5?
Yeah, June 5 and
Okay.
June 12.
At 10 a.m.?
Yeah.
June 5 and June 12,
Yeah.
and June 5 is at 10 too.
All both at 10. We have been taking these days because other committees are pressuring us into
I won't be here
for space. So,
10.
but I'm confident we should finish within these 2 days, and then we set the date for the report.
June 5 and June 12.
Let me thank you, ladies and gentlemen. We adjourn on 5th, 10 a.m. Okay.